Title IV. Property relations between husband and wife. Chapter 1. General Provisions. Art. 74. The property relationship between husband and wife shall be governed in the following order. 1. By marriage settlements executed before the marriage. 2. By the provisions of this code, and 3. By the local custom. 118. Art. 75. The future spouses may, in the marriage settlements, agree upon the regime of absolute community, conjugal partnership of gains, complete separation of property, or any other regime. In the absence of a marriage settlement, or when the regime agreed upon is void, the system of absolute community of property as established in this code shall govern. 119a. Art. 76. In order that any modification in the marriage settlements may be valid, it must be made before the celebration of the marriage, subject to the provisions of Articles 66, 67, 128, 135 and 136. 121. Art. 77. The marriage settlements and any modification thereof shall be in writing, signed by the parties and executed before the celebration of the marriage. They shall not prejudice third persons unless they are registered in the local civil registry, where the marriage contract is recorded, as well as in the proper registries of properties. 122a. Art. 78. A minor, who according to law may contract marriage, may also execute his or her marriage settlements, but they shall be valid only if the persons designated in Article 14 to give consent to the marriage are made parties to the agreement, subject to the provisions of Title X of this code. 120a. Art. 79. For the validity of any marriage settlement executed by a person upon whom a sentence of civil interdiction has been pronounced, or who is subject to any other disability, it shall be indispensable for the guardian appointed by a competent court to be made a party thereto. 123a. Art. 80. In the absence of a contrary stipulation in a marriage settlement, the property relations of the spouses shall be governed by Philippine laws, regardless of the place of the celebration of the marriage and their residence. This rule shall not apply: 1. Where both spouses are aliens. 2. With respect to the extrinsic validity of contracts affecting property not situated in the Philippines and executed in the country where the property is located, and 3. With respect to the extrinsic validity of contracts entered into in the Philippines but affecting property situated in a foreign country whose laws require different formalities for its extrinsic validity. 124a. Art. 81. Everything stipulated in the settlements or contracts referred to in the preceding articles in consideration of a future marriage, including donations between the prospective spouses made therein, shall be rendered void if the marriage does not take place. However, stipulations that do not depend upon the celebration of the marriages shall be valid. 125a. Chapter 2. Donations by reason of marriage. Art. 82. Donations by reason of marriage are those which are made before its celebration, in consideration of the same, and in favor of one or both of the future spouses. 126. Art. 83. These donations are governed by the rules on ordinary donations established in Title 3 of Book 3 of the Civil Code, insofar as they are not modified by the following articles. 127a. Art. 84. If the future spouses agree upon a regime other than the absolute community of property, they cannot donate to each other in their marriage settlements more than 1/5 of their present property. Any excess shall be considered void. Donations of future property shall be governed by the provisions on testamentary succession and the formalities of wills. 130a. Art. 85. Donations by reason of marriage of property subject to encumbrances shall be valid. In case of foreclosure of the encumbrance and the property is sold for less than the total amount of the obligation secured, the donee shall not be liable for the deficiency. If the property is sold for more than the total amount of said obligation, the donee shall be entitled to the excess. 131a. Art. 86. A donation by reason of marriage may be revoked by the donor in the following cases. 1. If the marriage is not celebrated or judicially declared void ab initio, except donations made in the marriage settlements, which shall be governed by Article 81. 2. When the marriage takes place without the consent of the parents or guardian, as required by law. 3. When the marriage is annulled, and the donee acted in bad faith. 4. Upon legal separation, the donee being the guilty spouse. 5. If it is with a resolutory condition and the condition is complied with. 6. When the donee has committed an act of ingratitude as specified by the provisions of the Civil Code on Donations in General. 132a. Art. 87. Every donation or grant of gratuitous advantage, direct or indirect, between the spouses during the marriage shall be void, except moderate gifts which the spouses may give each other on the occasion of any family rejoicing. The prohibition shall also apply to persons living together as husband and wife without a valid marriage. 133a. Chapter 3. System of Absolute Community. Section 1. General Provisions. Art. 88. The absolute community of property between spouses shall commence at the precise moment that the marriage is celebrated. Any stipulation, express or implied, for the commencement of the community regime at any other time shall be void. 145a. Art. 89. No waiver of rights, shares and effects of the absolute community of property during the marriage can be made except in case of judicial separation of property. When the waiver takes place upon a judicial separation of property, or after the marriage has been dissolved or annulled, the same shall appear in a public instrument and shall be recorded as provided in Article 77. The creditors of the spouse who made such waiver may petition the court to rescind the waiver, to the extent of the amount sufficient to cover the amount of their credits. 146a. Art. 90. The provisions on co-ownership shall apply to the absolute community of property between the spouses in all matters not provided for in this chapter. N. Section 2. What constitutes community property? Art. 91. Unless otherwise provided in this chapter or in the marriage settlements, the community property shall consist of all the property owned by the spouses at the time of the celebration of the marriage or acquired thereafter. 197a. Art. 92. The following shall be excluded from the community property. 1. Property acquired during the marriage by gratuitous title by either spouse, and the fruits as well as the income thereof, if any, unless it is expressly provided by the donor, testator or grantor that they shall form part of the community property. 2. Property for personal and exclusive use of either spouse. However, jewelry shall form part of the community property. 3. Property acquired before the marriage by either spouse who has legitimate descendants by a former marriage, and the fruits as well as the income, if any, of such property. 201a. Art. 93. Property acquired during the marriage is presumed to belong to the community, unless it is proved that it is one of those excluded therefrom. 160. Section 3. Charges and obligations of the absolute community. Art. 94. The absolute community of property shall be liable for 1. The support of the spouses, their common children, and legitimate children of either spouse. However, the support of illegitimate children shall be governed by the provisions of this code on support. 2. All debts and obligations contracted during the marriage by the designated administrator spouse for the benefit of the community, or by both spouses, or by one spouse with the consent of the other. 3. Debts and obligations contracted by either spouse without the consent of the other to the extent that the family may have been benefited. 4. All taxes, liens, charges and expenses, including major or minor repairs, upon the community property. 5. All taxes and expenses for mere preservation made during marriage upon the separate property of either spouse used by the family. 6. Expenses to enable either spouse to commence or complete a professional or vocational course, or other activity for self-improvement. 7. Antenuptial debts of either spouse insofar as they have redounded to the benefit of the family. 8. The value of what is donated or promised by both spouses in favor of their common legitimate children, for the exclusive purpose of commencing or completing a professional or vocational course or other activity for self-improvement. 9. Antenuptial debts of either spouse other than those falling under paragraph 7 of this article, the support of illegitimate children of either spouse, and liabilities incurred by either spouse by reason of a crime or a quasi-delict, in case of absence or insufficiency of the exclusive property of the debtor spouse, the payment of which shall be considered as advances to be deducted from the share of the debtor spouse upon liquidation of the community, and 10. Expenses of litigation between the spouses unless the suit is found to be groundless, if the community property is insufficient to cover the foregoing liabilities, except those falling under paragraph 9. The spouses shall be solidarily liable for the unpaid balance with their separate properties. 161A, 162A, 163A, 202A, 205A. Art. 95. Whatever may be lost during the marriage in any game of chance, betting, sweepstakes, or any other kind of gambling, whether permitted or prohibited by law, shall be borne by the loser and shall not be charged to the community, but any winnings therefrom shall form part of the community property. 164A. Section 4. Ownership, administrative, enjoyment and disposition of the community property. Art. 96. The administration and enjoyment of the community property shall belong to both spouses jointly. In case of disagreement, the husband's decision shall prevail, subject to recourse to the court by the wife for proper remedy, which must be availed of within 5 years from the date of the contract implementing such decision. In the event that one spouse is incapacitated or otherwise unable to participate in the administration of the common properties, the other spouse may assume sole powers of administration. These powers do not include disposition or encumbrance without authority of the court or the written consent of the other spouse. In the absence of such authority or consent, the disposition or encumbrance shall be void. However, the transaction shall be construed as a continuing offer on the part of the consenting spouse and the third person, and may be perfected as a binding contract upon the acceptance by the other spouse or authorization by the court before the offer is withdrawn by either or both offerers. 206A. Art. 97. Either spouse may dispose by will of his or her interest in the community property. N. Art. 98. Neither spouse may donate any community property without the consent of the other. However, either spouse may, without the consent of the other, make moderate donations from the community property for charity or on occasions of family rejoicing or family distress. N. Section 5. Dissolution of absolute community regime. Art. 99. The absolute community terminates 1. Upon the death of either spouse. 2. When there is a decree of legal separation. 3. When the marriage is annulled or declared void, or 4. In case of judicial separation of property during the marriage under Article 134 to 138. 175a. Art. 100. The separation in fact between husband and wife shall not affect the regime of absolute community except that 1. The spouse who leaves the conjugal home or refuses to live therein, without just cause, shall not have the right to be supported. 2. When the consent of one spouse to any transaction of the other is required by law, judicial authorization shall be obtained in a summary proceeding. 3. In the absence of sufficient community property, the separate property of both spouses shall be solidarily liable for the support of the family. The spouse present shall, upon proper petition in a summary proceeding, be given judicial authority to administer or encumber any specific separate property of the other spouse and use the fruits or proceeds thereof to satisfy the latter's share. 178a. Art. 101. If a spouse without just cause abandons the other or fails to comply with his or her obligations to the family, the aggrieved spouse may petition the court for receivership, for judicial separation of property, or for authority to be the sole administrator of the absolute community, subject to such precautionary conditions as the court may impose. The obligations to the family mentioned in the preceding paragraph refer to marital, parental or property relations. A spouse is deemed to have abandoned the other when he or she has left the conjugal dwelling without intention of returning. The spouse who has left the conjugal dwelling for a period of 3 months or has failed within the same period to give any information as to his or her whereabouts shall be prima facie presumed to have no intention of returning to the conjugal dwelling. 178a. Section 6. Liquidation of the absolute community assets and liabilities. Art. 102. Upon dissolution of the absolute community regime, the following procedure shall apply. 1. An inventory shall be prepared, listing separately all the properties of the absolute community and the exclusive properties of each spouse. 2. The debts and obligations of the absolute community shall be paid out of its assets. In case of insufficiency of said assets, the spouses shall be solidarily liable for the unpaid balance with their separate properties in accordance with the provisions of the second paragraph of Article 94. 3. Whatever remains of the exclusive properties of the spouses shall thereafter be delivered to each of them. 4. The net remainder of the properties of the absolute community shall constitute its net assets, which shall be divided equally between husband and wife, unless a different proportion or division was agreed upon in the marriage settlements, or unless there has been a voluntary waiver of such share provided in this code, for purpose of computing the net profit subject to forfeiture in accordance with Articles 43. Number 2, and 63, Number 2, the said profits shall be the increase in value between the market value of the community property at the time of the celebration of the marriage and the market value at the time of its dissolution. 5. The presumptive legitimates of the common children shall be delivered upon partition, in accordance with Article 51. 6. Unless otherwise agreed upon by the parties, in the partition of the properties, the conjugal dwelling and the lot on which it is situated shall be adjudicated to the spouse with whom the majority of the common children choose to remain. Children below the age of 7 years are deemed to have chosen the mother, unless the court has decided otherwise. In case there is no such majority, the court shall decide, taking into consideration the best interests of said children. N. Art. 103. Upon the termination of the marriage by death, the community property shall be liquidated in the same proceeding for the settlement of the estate of the deceased. If no judicial settlement proceeding is instituted, the surviving spouse shall liquidate the community property either judicially or extrajudicially within 6 months from the death of the deceased spouse. If upon the lapse of the 6 months period, no liquidation is made, any disposition or encumbrance involving the community property of the terminated marriage shall be void. Should the surviving spouse contract a subsequent marriage without compliance with the foregoing requirements, a mandatory regime of complete separation of property shall govern the property relations of the subsequent marriage. N. Art. 104. Whenever the liquidation of the community properties of 2 or more marriages contracted by the same person before the effectivity of this code is carried out, simultaneously, the respective capital, fruits and income of each community shall be determined upon such proof as may be considered according to the rules of evidence. In case of doubt as to which community the existing properties belong, the same shall be divided between the different communities in proportion to the capital and duration of each. 189a. Chapter 4. Conjugal Partnership of Gains. Section 1. General Provisions. Art. 105. In case the future spouses agree in the marriage settlements that the regime of conjugal partnership gains shall govern their property relations during marriage, the provisions in this chapter shall be of supplementary application. The provisions of this chapter shall also apply to conjugal partnerships of gains already established between spouses before the effectivity of this code, without prejudice to vested rights already acquired in accordance with the Civil Code or other laws, as provided in Article 256. N. Art. 106. Under the regime of conjugal partnership of gains, the husband and wife place in a common fund the proceeds, products, fruits and income from their separate properties and those acquired by either or both spouses through their efforts or by chance, and, upon dissolution of the marriage or of the partnership, the net gains or benefits obtained by either or both spouses shall be divided equally between them, unless otherwise agreed in the marriage settlements. 142a. Art. 107. The rules provided in Articles 88 and 89 shall also apply to conjugal partnership of gains. N. Art. 108. The conjugal partnership shall be governed by the rules on the contract of partnership in all that is not in conflict with what is expressly determined in this chapter or by the spouses in their marriage settlements. 147a. Section 2. Exclusive property of each spouse. Art. 109. The following shall be the exclusive property of each spouse. 1. That which is brought to the marriage as his or her own. 2. That which each acquires during the marriage by gratuitous title. 3. That which is acquired by right of redemption, by barter or by exchange with property belonging to only one of the spouses, and 4. That which is purchased with exclusive money of the wife or of the husband. 148a. Art. 110. The spouses retain the ownership, possession, administration and enjoyment of their exclusive properties. Either spouse may, during the marriage, transfer the administration of his or her exclusive property to the other by means of a public instrument which shall be recorded in the registry of property of the place the property is located. 137a, 168a, 169a. Art. 111. A spouse of age may mortgage, encumber, alienate, or otherwise dispose of his or her exclusive property without the consent of the other spouse, and appear alone in court to litigate with regard to the same. N. Art. 112. The alienation of any exclusive property of a spouse administered by the other, automatically terminates the administration over such property, and the proceeds of the alienation shall be turned over to the owner's spouse. N. Art. 113. Property donated or left by will to the spouses, jointly and with designation of determinate shares, shall pertain to the donee spouses as his or her own exclusive property, and in the absence of designation, share and share alike, without prejudice to the right of accretion when proper. 150a. Art. 114. If the donations are onerous, the amount of the charges shall be borne by the exclusive property of the donee spouse, whenever they have been advanced by the conjugal partnership of gains. 151a. Art. 115. Retirement benefits, pensions, annuities, gratuities, usufructs and similar benefits shall be governed by the rules on gratuitous or onerous acquisitions as may be proper in each case. N. Section 3. Conjugal partnership property. Art. 116. All property acquired during the marriage, whether the acquisition appears to have been made, contracted or registered in the name of one or both spouses, is presumed to be conjugal unless the contrary is proved. 160a. Art. 117. The following are conjugal partnership properties. 1. Those acquired by onerous title during the marriage at the expense of the common fund, whether the acquisition be for the partnership, or for only one of the spouses. 2. Those obtained from the labor, industry, work or profession of either or both of the spouses. 3. The fruits, natural, industrial, or civil, due or received during the marriage from the common property, as well as the net fruits from the exclusive property of each spouse. 4. The share of either spouse in the hidden treasure which the law awards to the finder or owner of the property where the treasure is found. 5. Those acquired through occupations such as fishing or hunting. 6. Livestock existing upon the dissolution of the partnership in excess of the number of each kind brought to the marriage by either spouse, and 7. Those which are acquired by chance, such as winnings from gambling or betting. However, losses therefrom shall be borne exclusively by the loser spouse. 153a, 154a, 155, 159. Art. 118. Property bought on installments paid partly from exclusive funds of either or both spouses and partly from conjugal funds belongs to the buyer or buyers if full ownership was vested before the marriage into the conjugal partnership if such ownership was vested during the marriage. In either case, any amount advanced by the partnership or by either or both spouses shall be reimbursed by the owner or owners upon liquidation of the partnership. N. Art. 119. Whenever an amount or credit payable within a period of time belongs to one of the spouses, the sums which may be collected during the marriage in partial payments or by installments on the principal shall be the exclusive property of the spouse. However, interests falling due during the marriage on the principal shall belong to the conjugal partnership. 156a, 157a. Art. 120. The ownership of improvements, whether for utility or adornment, made on the separate property of the spouses at the expense of the partnership or through the acts or efforts of either or both spouses shall pertain to the conjugal partnership, or to the original owner spouse, subject to the following rules. When the cost of the improvement made by the conjugal partnership and any resulting increase in value are more than the value of the property at the time of the improvement, the entire property of one of the spouses shall belong to the conjugal partnership, subject to reimbursement of the value of the property of the owner's spouse at the time of the improvement. Otherwise, said property shall be retained in ownership by the owner's spouse, likewise subject to reimbursement of the cost of the improvement. In either case, the ownership of the entire property shall be vested upon reimbursement, which shall be made at the time of the liquidation of the conjugal partnership. 158a. Section 4. Charges upon and obligations of the conjugal partnership. Art. 121. The conjugal partnership shall be liable for 1. The support of the spouse, their common children, and the legitimate children of either spouse. However, the support of illegitimate children shall be governed by the provisions of this code on support. 2. All debts and obligations contracted during the marriage by the designated administrator spouse for the benefit of the conjugal partnership of gains, or by both spouses or by one of them with the consent of the other. 3. Debts and obligations contracted by either spouse without the consent of the other to the extent that the family may have benefited. 4. All taxes, liens, charges, and expenses, including major or minor repairs upon the conjugal partnership property. 5. All taxes and expenses for mere preservation made during the marriage upon the separate property of either spouse. 6. Expenses to enable either spouse to commence or complete a professional, vocational, or other activity for self-improvement. 7. Antenuptial debts of either spouse insofar as they have redounded to the benefit of the family. 8. The value of what is donated or promised by both spouses in favor of their common legitimate children for the exclusive purpose of commencing or completing a professional or vocational course or other activity for self-improvement. And 9. Expenses of litigation between the spouses unless the suit is found to groundless. If the conjugal partnership is insufficient to cover the foregoing liabilities, the spouses shall be solidarily liable for the unpaid balance with their separate properties. 161a. Art. 122. The payment of personal debts contracted by the husband or the wife before or during the marriage shall not be charged to the conjugal properties partnership except in so far as they redounded to the benefit of the family. Neither shall the fines and pecuniary indemnities imposed upon them be charged to the partnership. However, the payment of personal debts contracted by either spouse before the marriage, that of fines and indemnities imposed upon them, as well as the support of illegitimate children of either spouse, may be enforced against the partnership assets after the responsibilities enumerated in the preceding article have been covered. If the spouse who is bound should have no exclusive property or if it should be insufficient, but at the time of the liquidation of the partnership, such spouse shall be charged for what has been paid for the purpose above mentioned. 163a. Art. 123. Whatever may be lost during the marriage in any game of chance or in betting, sweepstakes, or any other kind of gambling whether permitted or prohibited by law, shall be borne by the loser and shall not be charged to the conjugal partnership, but any winnings therefrom shall form part of the conjugal partnership property. 164a. Section 5. Administration of the conjugal partnership property. Art. 124. The administration and enjoyment of the conjugal partnership shall belong to both spouses jointly. In case of disagreement, the husband's decision shall prevail, subject to recourse to the court by the wife for proper remedy, which must be availed of within 5 years from the date of the contract implementing such decision. In the event that one spouse is incapacitated or otherwise unable to participate in the administration of the conjugal properties, the other spouse may assume sole powers of administration. These powers do not include disposition or encumbrance without authority of the court or the written consent of the other spouse. In the absence of such authority or consent, the disposition or encumbrance shall be void. However, the transaction shall be construed as a continuing offer on the part of the consenting spouse and the third person, and may be perfected as a binding contract upon the acceptance by the other spouse or authorization by the court before the offer is withdrawn by either or both offerers. 165a. Art. 125. Neither spouse may donate any conjugal partnership property without the consent of the other. However, either spouse may, without the consent of the other, make moderate donations from the conjugal partnership property for charity or on occasions of family rejoicing or family distress. 174a. Section 6. Dissolution of conjugal partnership regime. Art. 126. The conjugal partnership terminates 1. Upon the death of either spouse. 2. When there is a decree of legal separation. 3. When the marriage is annulled or declared void, or 4. In case of judicial separation of property during the marriage under Articles 134 to 138. 175a. Art. 127. The separation in fact between husband and wife shall not affect the regime of conjugal partnership, except that 1. The spouse who leaves the conjugal home or refuses to live therein, without just cause, shall not have the right to be supported. 2. When the consent of one spouse to any transaction of the other is required by law, judicial authorization shall be obtained in a summary proceeding. 3. In the absence of sufficient conjugal partnership property, the separate property of both spouses shall be solidarily liable for the support of the family. The spouse present shall, upon petition in a summary proceeding, be given judicial authority to administer or encumber any specific separate property of the other spouse and use the fruits or proceeds thereof to satisfy the latter's share. 178a. Art. 128. If a spouse without just cause abandons the other or fails to comply with his or her obligation to the family, the aggrieved spouse may petition the court for receivership, for judicial separation of property, or for authority to be the sole administrator of the conjugal partnership property, subject to such precautionary conditions as the court may impose. The obligations to the family mentioned in the preceding paragraph refer to marital, parental or property relations. A spouse is deemed to have abandoned the other when he or she has left the conjugal dwelling without intention of returning. The spouse who has left the conjugal dwelling for a period of 3 months or has failed within the same period to give any information as to his or her whereabouts shall be prima facie presumed to have no intention of returning to the conjugal dwelling. 167a. 191a. Section 7. Liquidation of the conjugal partnership assets and liabilities. Art. 129. Upon the dissolution of the conjugal partnership regime, the following procedure shall apply. 1. An inventory shall be prepared, listing separately all the properties of the conjugal partnership and the exclusive properties of each spouse. 2. Amounts advanced by the conjugal partnership in payment of personal debts and obligations of either spouse shall be credited to the conjugal partnership as an asset thereof. 3. Each spouse shall be reimbursed for the use of his or her exclusive funds in the acquisition of property or for the value of his or her exclusive property, the ownership of which has been vested by law in the conjugal partnership. 4. The debts and obligations of the conjugal partnership shall be paid out of the conjugal assets. In case of insufficiency of said assets, the spouses shall be solidarily liable for the unpaid balance with their separate properties, in accordance with the provisions of paragraph 2 of Article 121. 5. Whatever remains of the exclusive properties of the spouses shall thereafter be delivered to each of them. 6. Unless the owner had been indemnified from whatever source, the loss or deterioration of movables used for the benefit of the family belonging to either spouse, even due to fortuitous event, shall be paid to said spouse from the conjugal funds, if any. 7. The net remainder of the conjugal partnership properties shall constitute the profits, which shall be divided equally between husband and wife, unless a different proportion or division was agreed upon in the marriage settlements, or unless there has been a voluntary waiver or forfeiture of such share as provided in this code. 8. The presumptive legitimates of the common children shall be delivered upon the partition in accordance with Article 51. 9. In the partition of the properties, the conjugal dwelling and the lot on which it is situated shall, unless otherwise agreed upon by the parties, be adjudicated to the spouse with whom the majority of the common children choose to remain. Children below the age of 7 years are deemed to have chosen the mother, unless the court has decided otherwise. In case there is no such majority, the court shall decide, taking into consideration the best interests of said children. 181a, 182a, 183a, 184a, 185a. Art. 130. Upon the termination of the marriage by death, the conjugal partnership property shall be liquidated in the same proceeding for the settlement of the estate of the deceased. If no judicial settlement proceeding is instituted, the surviving spouse shall liquidate the conjugal partnership property either judicially or extrajudicially within 6 months from the death of the deceased spouse. If upon the lapse of the 6-month period no liquidation is made, any disposition or encumbrance involving the conjugal partnership property of the terminated marriage shall be void. Should the surviving spouse contract a subsequent marriage without compliance with the foregoing requirements, a mandatory regime of complete separation of property shall govern the property relations of the subsequent marriage. N. Art. 131. Whenever the liquidation of the conjugal partnership properties of 2 or more marriages contracted by the same person before the effectivity of this code is carried out, simultaneously, the respective capital, fruits and income of each partnership shall be determined upon such proof as may be considered according to the rules of evidence. In case of doubt as to which partnership the existing properties belong, the same shall be divided between the different partnerships in proportion to the capital and duration of each. 189a. Art. 132. The rules of court on the administration of estates of deceased persons shall be observed in the appraisal and sale of property of the conjugal partnership, and other matters which are not expressly determined in this chapter. 187a. Art. 133. From the common mass of property support shall be given to the surviving spouse and to the children during the liquidation of the inventoried property and until what belongs to them is delivered, but from this shall be deducted that amount received for support which exceeds the fruits or rents pertaining to them. 188a. Chapter 5. Separation of property of the spouses and administration of common property by one spouse during the marriage. Art. 134. In the absence of an express declaration in the marriage settlements, the separation of property between spouses during the marriage shall not take place except by judicial order. Such judicial separation of property may either be voluntary or for sufficient cause. 190a. Art. 135. Any of the following shall be considered sufficient cause for judicial separation of property. 1. That the spouse of the petitioner has been sentenced to a penalty which carries with it civil interdiction. 2. That the spouse of the petitioner has been judicially declared an absentee. 3. That loss of parental authority of the spouse of petitioner has been decreed by the court. 4. That the spouse of the petitioner has abandoned the latter or failed to comply with his or her obligations to the family is provided for in Article 101. 5. That the spouse granted the power of administration in the marriage settlements has abused that power, and 6. That at the time of the petition, the spouses have been separated in fact for at least 1 year and reconciliation is highly improbable. In the cases provided for in Numbers 1, 2, and 3, the presentation of the final judgment against the guilty or absent spouse shall be enough basis for the grant of the decree of judicial separation of property. 191a. Art. 136. The spouses may jointly file a verified petition with the court for the voluntary dissolution of the absolute community or the conjugal partnership of gains, and for the separation of their common properties. All creditors of the absolute community or of the conjugal partnership of gains, as well as the personal creditors of the spouse, shall be listed in the petition and notified of the filing thereof. The court shall take measures to protect the creditors and other persons with pecuniary interest. 191a. Art. 137. Once the separation of property has been decreed, the absolute community or the conjugal partnership of gains shall be liquidated in conformity with this code. During the pendency of the proceedings for separation of property, the absolute community or the conjugal partnership shall pay for the support of the spouses and their children. 192a. Art. 138. After dissolution of the absolute community or of the conjugal partnership, the provisions on complete separation of property shall apply. 191a. Art. 139. The petition for separation of property and the final judgment granting the same shall be recorded in the proper local civil registries and registries of property. 193a. Art. 140. The separation of property shall not prejudice the rights previously acquired by creditors. 194a. Art. 141. The spouses may, in the same proceedings where separation of property was decreed, file a motion in court for a decree reviving the property regime that existed between them before the separation of property in any of the following instances. 1. When the civil interdiction terminates. 2. When the absentee spouse reappears. 3. When the court, being satisfied that the spouse granted the power of administration in the marriage settlements will not again abuse that power, authorizes the resumption of said administration. 4. When the spouse who has left the conjugal home without a decree of legal separation resumes common life with the other. 5. When parental authority is judicially restored to the spouse previously deprived thereof. 6. When the spouses who have separated in fact for at least 1 year reconcile and resume common life, or 7. When after voluntary dissolution of the absolute community of property or conjugal partnership has been judicially decreed upon the joint petition of the spouses, they agree to the revival of the former property regime. No voluntary separation of property may thereafter be granted. The revival of the former property regime shall be governed by Article 67, 195a. Art. 142. The administration of all classes of exclusive property of either spouse may be transferred by the court to the other spouse. 1. When one spouse becomes the guardian of the other. 2. When one spouse is judicially declared an absentee. 3. When one spouse is sentenced to a penalty which carries with it civil interdiction, or 4. When one spouse becomes a fugitive from justice or is in hiding as an accused in a criminal case. If the other spouse is not qualified by reason of incompetence, conflict of interest, or any other just cause, the court shall appoint a suitable person to be the administrator. N. Chapter 6. Regime of separation of property. Art. 143. Should the future spouses agree in the marriage settlements that their property relations during marriage shall be governed by the regime of separation of property. The provisions of this chapter shall be supplementary. 212a. Art. 144. Separation of property may refer to present or future property or both. It may be total or partial. In the latter case, the property not agreed upon as separate shall pertain to the absolute community. 213a. Art. 145. Each spouse shall own, dispose of, possess, administer and enjoy his or her own separate estate, without need of the consent of the other. To each spouse shall belong all earnings from his or her profession, business or industry, and all fruits, natural, industrial or civil, to her received during the marriage from his or her separate property. 214a. Art. 146. Both spouses shall bear the family expenses in proportion to their income, or, in case of insufficiency or default thereof, to the current market value of their separate properties. The liabilities of the spouses to creditors for family expenses shall, however, be solidary. 215a. Chapter 7. Property regime of unions without marriage. Art. 147. When a man and a woman who are capacitated to marry each other live exclusively with each other as husband and wife without the benefit of marriage or under a void marriage, their wages and salaries shall be owned by them in equal shares, and the property acquired by both of them through their work or industry shall be governed by the rules on co-ownership. In the absence of proof to the contrary, properties acquired while they lived together shall be presumed to have been obtained by their joint efforts, work or industry, and shall be owned by them in equal shares. For purposes of this article, a party who did not participate in the acquisition by the other party of any property shall be deemed to have contributed jointly in the acquisition thereof if the former's efforts consisted in the care and maintenance of the family and of the household. Neither party can encumber or dispose by acts inter vivos of his or her share in the property acquired during cohabitation and owned in common, without the consent of the other, until after the termination of their cohabitation, when only one of the parties to avoid marriage is in good faith. The share of the party in bad faith in the co-ownership shall be forfeited in favor of their common children, in case of default of or waiver by any or all of the common children or their descendants. Each vacant share shall belong to the respective surviving descendants. In the absence of descendants, such share shall belong to the innocent party. In all cases, the forfeiture shall take place upon termination of the cohabitation. 144a. Art. 148. In cases of cohabitation not falling under the preceding article, only the properties acquired by both of the parties through their actual joint contribution of money, property, or industry shall be owned by them in common in proportion to their respective contributions. In the absence of proof to the contrary, their contributions and corresponding shares are presumed to be equal. The same rule and presumption shall apply to joint deposits of money and evidences of credit. If one of the parties is validly married to another, his or her share in the co-ownership shall accrue to the absolute community or conjugal partnership existing in such valid marriage. If the party who acted in bad faith is not validly married to another, his or her shall be forfeited in the manner provided in the last paragraph of the preceding article. The foregoing rules on forfeiture shall likewise apply even if both parties are in both faith. 144a. Title V. The Family. Chapter 1. The Family as an Institution. Art. 149. The family, being the foundation of the nation, is a basic social institution which public policy cherishes and protects. Consequently, family relations are governed by law and no custom. practice or agreement destructive of the family shall be recognized or given effect. 216a, 218a. Art. 50. Family relations include those 1. Between husband and wife. 2. Between parents and children. 3. Among brothers and sisters, whether of the full or half-blood. 217a. Art. 151. No suit between members of the same family shall prosper unless it should appear from the verified complaint or petition that earnest efforts toward a compromise have been made, but that the same have failed. If it is shown that no such efforts were in fact made, the same case must be dismissed. This rule shall not apply to cases which may not be the subject of compromise under the Civil Code. 222a. Chapter 2. The Family Home. Art. 152. The family home, constituted jointly by the husband and the wife or by an unmarried head of a family, is the dwelling house where they and their family reside, and the land on which it is situated. 223a. Art. 153. The family home is deemed constituted on a house and lot from the time it is occupied as a family residence, from the time of its constitution and so long as any of its beneficiaries actually resides therein. The family home continues to be such and is exempt from execution, forced sale or attachment except as hereinafter provided and to the extent of the value allowed by law. 223a. Art. 154. The beneficiaries of a family home are 1. The husband and wife, or an unmarried person who is the head of a family, and 2. Their parents, ascendants, descendants, brothers and sisters, whether the relationship be legitimate or illegitimate, who are living in the family home and who depend upon the head of the family for legal support. 226a. Art. 155. The family home shall be exempt from execution, forced sale or attachment except 1. For non-payment of taxes. 2. For debts incurred prior to the constitution of the family home. 3. For debts secured by mortgages on the premises before or after such constitution, and 4. For debts due to laborers, mechanics, architects, builders, material men and others who have rendered service or furnished material for the construction of the building. 243a. Art. 156. The family home must be part of the properties of the absolute community or the conjugal partnership, or of the exclusive properties of either spouse with the latter's consent. It may also be constituted by an unmarried head of a family on his or her own property. Nevertheless, property that is the subject of a conditional sale on installments where ownership is reserved by the vendor only to guarantee payment of the purchase price may be constituted as a family home. 227a, 228a. Art. 157. The actual value of the family home shall not exceed, at the time of its constitution, the amount of the 300,000 pesos in urban areas, and 200,000 pesos in rural areas, or such amounts as may hereafter be fixed by law. In any event, if the value of the currency changes after the adoption of this code, the value most favorable for the constitution of a family home shall be the basis of evaluation. For purposes of this article, urban areas are deemed to include chartered cities and municipalities whose annual income at least equals that legally required for chartered cities. All others are deemed to be rural areas. 231a. Art. 158. The family home may be sold, alienated, donated, assigned or encumbered by the owner or owners thereof with the written consent of the person constituting the same, the latter's spouse, and a majority of the beneficiaries of legal age. In case of conflict, the court shall decide. 235a. Art. 159. The family home shall continue despite the death of one or both spouses or of the unmarried head of the family, for a period of 10 years or for as long as there is a minor beneficiary, and the heirs cannot partition the same unless the court finds compelling reasons. Therefore, this rule shall apply regardless of whoever owns the property or constituted the family home. 238a. Art. 160. When a creditor whose claims is not among those mentioned in Article 155 obtains a judgment in his favor, and he has reasonable grounds to believe that the family home is actually worth more than the maximum amount fixed in Article 157, he may apply to the court which rendered the judgment for an order directing the sale of the property under execution. The court shall so order if it finds that the actual value of the family home exceeds the maximum amount allowed by laws of the time of its constitution. If the increased actual value exceeds the maximum allowed in Article 157 and results from subsequent voluntary improvements introduced by the person or persons constituting the family home, by the owner or owners of the property, or by any of the beneficiaries, the same rule and procedure shall apply. At the execution sale, no bid below the value allowed for a family home shall be considered. The proceeds shall be applied first to the amount mentioned in Article 157, and then to the liabilities under the judgment and the costs. The excess, if any, shall be delivered to the judgment debtor. 247a. 248a. Art. 161. For purposes of availing of the benefits of a family home as provided for in this chapter, a person may constitute, or be the beneficiary of, only one family home. N. Art. 162. The provisions in this chapter shall also govern existing family residences insofar as said provisions are applicable. N. Title V. Paternity and Filiation. Chapter 1. Legitimate children. Art. 163. The filiation of children may be by nature or by adoption. Natural filiation may be legitimate or illegitimate. N. Art. 164. Children conceived or born during the marriage of the parents are legitimate. Children conceived as a result of artificial insemination of the wife with the sperm of the husband or that of a donor or both are likewise legitimate children of the husband and his wife, provided that both of them authorized or ratified such insemination in a written instrument executed and signed by them before the birth of the child. The instrument shall be recorded in the civil registry together with the birth certificate of the child. 55a. 258a. Art. 165. Children conceived and born outside a valid marriage are illegitimate, unless otherwise provided in this code. N. Art. 166. Legitimacy of a child may be impugned only on the following grounds. 1. That it was physically impossible for the husband to have sexual intercourse with his wife within the first 120 days of the 300 days which immediately preceded the birth of the child, because of a. The physical incapacity of the husband to have sexual intercourse with his wife, b. The fact that the husband and wife were living separately in such a way that sexual intercourse was not possible, or c. Serious illness of the husband, which absolutely prevented sexual intercourse. 2. That it is proved that for biological or other scientific reasons, the child could not have been that of the husband, except in the instance provided in the second paragraph of Article 164, or 3. That in case of children conceived through artificial insemination, the written authorization or ratification of either parent was obtained through mistake, fraud, violence, intimidation, or undue influence. 255a. Art. 167. The child shall be considered legitimate although the mother may have declared against its legitimacy or may have been sentenced as an adulteress. 256a. Art. 168. If the marriage is terminated and the mother contracted another marriage within 300 days after such termination of the former marriage, these rules shall govern in the absence of proof to the contrary. 1. A child born before 180 days after the solemnization of the subsequent marriage is considered to have been conceived during the former marriage, provided it be born within 300 days after the termination of the former marriage. 2. A child born after 180 days following the celebration of the subsequent marriage is considered to have been conceived during such marriage, even though it be born within the 300 days after the termination of the former marriage. 259a. Art. 169. The legitimacy or illegitimacy of a child born after 300 days following the termination of the marriage shall be proved by whoever alleges such legitimacy or illegitimacy. 261a. Art. 170. The action to impugn the legitimacy of the child shall be brought within 1 year from the knowledge of the birth or its recording in the civil register, if the husband or, in a proper case, any of his heirs, should reside in the city or municipality where the birth took place or was recorded. If the husband or, in his default, all of his heirs do not reside at the place of birth as defined in the first paragraph or where it was recorded, the period shall be 2 years if they should reside in the Philippines, and 3 years if abroad. If the birth of the child has been concealed from or was unknown to the husband or his heirs, the period shall be counted from the discovery or knowledge of the birth of the child or of the fact of registration of said birth, whichever is earlier. 263a. Art. 171. The heirs of the husband may impugn the filiation of the child within the period prescribed in the preceding article only in the following cases. 1. If the husband should die before the expiration of the period fixed for bringing his action. 2. If he should die after the filing of the complaint without having desisted therefrom, or 3. If the child was born after the death of the husband. 262a. Chapter 2. Proof of Filiation. Art. 172. The filiation of legitimate children is established by any of the following. 1. The record of birth appearing in the civil register or a final judgment, or 2. An admission of legitimate filiation in a public document or a private handwritten instrument and signed by the parent concerned. In the absence of the foregoing evidence, the legitimate filiation shall be proved by 1. The open and continuous possession of the status of a legitimate child, or 2. Any other means allowed by the rules of court and special laws. 265a, 266a, 267a. Art. 173. The action to claim legitimacy may be brought by the child during his or her lifetime, and shall be transmitted to the heirs should the child die during minority or in the state of insanity. In these cases, the heirs shall have a period of 5 years within which to institute the action. Art. 174. Legitimate children shall have the right 1. To bear the surnames of the father and the mother, in conformity with the provisions of the Civil Code on surnames. 2. To receive support from their parents, their ascendants, and in proper cases, their brothers and sisters, in conformity with the provisions of this code on support, and 3. To be entitled to the legitimate and other successional rights granted to them by the Civil Code. 264a. Chapter 3. Illegitimate children. Art. 175. Illegitimate children may establish their illegitimate filiation in the same way and on the same evidence as legitimate children. The action must be brought within the same period specified in Article 173. except when the action is based on the second paragraph of Article 172, in which case the action may be brought during the lifetime of the alleged parent. 289a. Art. 176. Illegitimate children shall use the surname and shall be under the parental authority of their mother, and shall be entitled to support, in conformity with this code. The legitimacy of each illegitimate child shall consist of 1/2 of the legitimacy of a legitimate child, except for this modification. All other provisions in the Civil Code governing successional rights shall remain in force. 287a. Chapter 4. Legitimated children. Art. 177. Only children conceived and born outside of wedlock of parents who, at the time of the conception of the former, were not disqualified by any impediment to marry each other may be legitimated. 269a. Art. 178. Legitimation shall take place by a subsequent valid marriage between parents. The annulment of a violable marriage shall not affect the legitimation. 270a. Art. 179. Legitimated children shall enjoy the same rights as legitimate children. 272a. Art. 180. The effects of legitimation shall retroact to the time of the child's birth. 273a. Art. 181. The legitimation of children who died before the celebration of the marriage shall benefit their descendants. 274. Art. 182. Legitimation may be impugned only by those who are prejudiced in their rights within 5 years from the time their cause of action accrues. 275a. Title 7. Adoption. Art. 183. A person of age and in possession of full civil capacity and legal rights may adopt, provided he is in a position to support and care for his children, legitimate or illegitimate, in keeping with the means of the family. Only minors may be adopted, except in the cases when the adoption of a person of majority age is allowed in this title. In addition, the adopter must be at least 16 years older than the person to be adopted, unless the adopter is the parent by nature of the adopted, or is the spouse of the legitimate parent of the person to be adopted. 27 EO 91 and PD 603. Art. 184. The following persons may not adopt. 1. The guardian with respect to the ward prior to the approval of the final accounts rendered upon the termination of their guardianship relation. 2. Any person who has been convicted of a crime involving moral turpitude. 3. An alien, except a former Filipino citizen who seeks to adopt a relative by consanguinity. B. One who seeks to adopt the legitimate child of his or her Filipino spouse, or C. One who is married to a Filipino citizen and seeks to adopt, jointly with his or her spouse, a relative by consanguinity of the latter. Aliens not included in the foregoing exceptions may adopt Filipino children in accordance with the rules on inter-country adoptions as may be provided by law. 28a EO 91 and PD 603. Art. 185. Husband and wife must jointly adopt, except in the following cases. 1. When one spouse seeks to adopt his own illegitimate child, or 2. When one spouse seeks to adopt the legitimate child of the other. 29a EO 91 and PD 603. Art. 186. In case husband and wife jointly adopt or one spouse adopts the legitimate child of the other, joint parental authority shall be exercised by the spouses in accordance with this Code. 29a EO and PD 603. Art. 187. The following may not be adopted. 1. A person of legal age, unless he or she is a child by nature of the adopter or his or her spouse, or, prior to the adoption, said person has been consistently considered and treated by the adopter as his or her own child during minority. 2. An alien with whose government the Republic of the Philippines has no diplomatic relations. And 3. A person who has already been adopted unless such adoption has been previously revoked or rescinded. 30A, EO 91 and PD 603. Art. 188. The written consent of the following to the adoption shall be necessary. 1. The person to be adopted, if 10 years of age or over. 2. The parents by nature of the child, the legal guardian, or the proper government instrumentality. 3. The legitimate and adopted children, 10 years of age or over, of the adopting parent or parents. 4. The illegitimate children, 10 years of age or over, of the adopting parent, if living with said parent, and the latter's spouse, if any, and 5. The spouse, if any, of the person adopting her to be adopted. 31A, EO 91 and PD 603. Art. 189. Adoption shall have the following effects. 1. For civil purposes, the adopted shall be deemed to be a legitimate child of the adopters, and both shall acquire the reciprocal rights and obligations arising from the relationship of parent and child, including the right of the adopted to use the surname of the adopters. 2. The parental authority of the parents by nature over the adopted shall terminate and be vested in the adopters, except that if the adopter is the spouse of the parent by nature of the adopted, parental authority over the adopted shall be exercised jointly by both spouses, and 3. The adopted shall remain an intestate heir of his parents and other blood relatives. 39, 1A, 3A, PD 603. Art. 190. Legal or intestate succession to the estate of the adopted shall be governed by the following rules. 1. Legitimate and illegitimate children and descendants and the surviving spouse of the adopted shall inherit from the adopted, in accordance with the ordinary rules of legal or intestate succession. 2. When the parents, legitimate or illegitimate, or the legitimate ascendants of the adopted concur with the adopter, they shall divide the entire estate, one half to be inherited by the parents or ascendants and the other half by the adopters. 3. When the surviving spouse or the illegitimate children of the adopted concur with the adopters, they shall divide the entire estate in equal shares, one half to be inherited by the spouse or the illegitimate children of the adopted and the other half by the adopters. 4. When the adopters concur with the illegitimate children and the surviving spouse of the adopted, they shall divide the entire estate in equal shares, 1/3 to be inherited by the illegitimate children, 1/3 by the surviving spouse, and 1/3 by the adopters. 5. When only the adopters survive, they shall inherit the entire estate, and 6. When only collateral blood relatives of the adopted survive, then the ordinary rules of legal or intestate succession shall apply. 39, 4A, PD 603. Art. 191. If the adopted is a minor or otherwise incapacitated, the adoption may be judicially rescinded upon petition of any person authorized by the court or proper government instrumental acting on his behalf, on the same grounds prescribed for loss or suspension of parental authority. If the adopted is at least 18 years of age, he may petition for judicial rescission of the adoption on the same grounds prescribed for disinheriting an ascendant. 40A, PD 603. Art. 192. The adopters may petition the court for the judicial rescission of the adoption in any of the following cases. 1. If the adopted has committed any act constituting ground for disinheriting a descendant, or 2. When the adopted has abandoned the home of the adopters during minority for at least 1 year, or, by some other acts, has definitely repudiated the adoption. 41a, PD 603. Art. 193. If the adopted minor has not reached the age of majority at the time of the judicial rescission of the adoption, the court in the same proceeding shall reinstate the parental authority of the parents by nature, unless the latter are disqualified or incapacitated, in which case the court shall appoint a guardian over the person and property of the minor. If the adopted person is physically or mentally handicapped, the court shall appoint in the same proceeding a guardian over his person or property or both. Judicial rescission of the adoption shall extinguish all reciprocal rights and obligations between the adopters and the adopted arising from the relationship of parent and child. The adopted shall likewise lose the right to use the surnames of the adopters and shall resume his surname prior to the adoption. The court shall accordingly order the amendment of the records in the proper registries. 42a, PD 603. Title 8. Support. Art. 194. Support comprises everything indispensable for sustenance, dwelling, clothing, medical attendance, education and transportation, in keeping with the financial capacity of the family. The education of the person entitled to be supported referred to in the preceding paragraph shall include his schooling or training for some profession, trade or vocation, even beyond the age of majority. Transportation shall include expenses in going to and from school, or to and from place of work. 290a. Art. 105. Subject to the provisions of the succeeding articles, the following are obliged to support each other to the whole extent set forth in the preceding article. 1. The spouses. 2. Legitimate ascendants and descendants. 3. Parents and their legitimate children and the legitimate and illegitimate children of the latter. 4. Parents and their illegitimate children and the legitimate and illegitimate children of the latter, and 5. Legitimate brothers and sisters, whether of full or half-blood. 291a. Art. 196. Brothers and sisters not legitimately related, whether of the full or half-blood, are likewise bound to support each other to the full extent set forth in Article 194, except only when the need for support of the brother or sister, being of age, is due to a cause imputable to the claimant's fault or negligence. 291a. Art. 197. In case of legitimate ascendants, descendants, whether legitimate or illegitimate, and brothers and sisters, whether legitimately or illegitimately related, only the separate property of the person obliged to give support shall be answerable, provided that in case the obliger has no separate property, the absolute community or the conjugal partnership, if financially capable, shall advance the support, which shall be deducted from the share of the spouse obliged upon the liquidation of the absolute community or of the conjugal partnership. N. Art. 198. During the proceedings for legal separation or for annulment of marriage, and for declaration of nullity of marriage, the spouses and their children shall be supported from the properties of the absolute community, or the conjugal partnership. After the final judgment granting the petition, the obligation of mutual support between the spouses ceases. However, in case of legal separation, the court may order that the guilty spouse shall give support to the innocent one, specifying the terms of such order. 292a. Art. 199. Whenever two or more persons are obliged to give support, the liability shall devolve upon the following persons in the order herein provided. 1. The spouse. 2. The descendants in the nearest degree. 3. The ascendants in the nearest degree, and 4. The brothers and sisters. 294a. Art. 200. When the obligation to give support falls upon two or more persons, The payment of the same shall be divided between them in proportion to the resources of each. However, in case of urgent need and by special circumstances, the judge may order only one of them to furnish the support provisionally, without prejudice to his right to claim from the other obligers the share due from them. When two or more recipients at the same time claim support from one and the same person legally obliged to give it, should the latter not have sufficient means to satisfy all claims, the order established in the preceding article shall be followed, unless the concurrent obligees should be the spouse and a child subject to parental authority, in which case the child shall be preferred. 295a. Art. 201. The amount of support, in the cases referred to in Articles 195 and 196, shall be in proportion to the resources or means of the giver and to the necessities of the recipient. 296a. Art. 202. Support in the cases referred to in the preceding article shall be reduced, or increased proportionately, according to the reduction or increase of the necessities of the recipient and the resources or means of the person obliged to furnish the same. 297a. Art. 203. The obligation to give support shall be demandable from the time the person who has a right to receive the same needs it for maintenance, but it shall not be paid except from the date of judicial or extrajudicial demand. Support pendenti lite may be claimed in accordance with the rules of court. Payment shall be made within the first 5 days of each corresponding month, or when the recipient dies, his heirs shall not be obliged to return what he has received in advance. 298a. Art. 204. The person obliged to give support shall have the option to fulfill the obligation, either by paying the allowance fixed, or by receiving and maintaining in the family dwelling the person who has a right to receive support. The latter alternative cannot be availed of in case there is a moral or legal obstacle thereto. 299a. Art. 205. The right to receive support under this title, as well as any money or property obtained as such support, shall not be levied upon on attachment or execution. 302a. Art. 206. When, without the knowledge of the person obliged to give support, it is given by a stranger, the latter shall have a right to claim the same from the former, unless it appears that he gave it without intention of being reimbursed. 2164a. Art. 207. When the person obliged to support another unjustly refuses or fails to give support when urgently needed by the latter, any third person may furnish support to the needy individual, with right of reimbursement from the person obliged to give support. This article shall particularly apply when the father or mother of a child under the age of majority unjustly refuses to support or fails to give support to the child when urgently needed. 2166a.